The prosecutors say that she stood to gain some $1.5 million in insurance and workers' comp payouts from her husband's death. And that was part of what drove her to kill. In court, the prosecution called Robert Azor to the stand. He is a police investigative accountant and testified as to Brophy's financial difficulties.
When I look at this, I think it's a shame because I really don't see a reason that they ever had to be behind on their Wells Fargo payment and then never would have had to borrow from the retirement fund. It kind of created this chain reaction that it just built and got bigger, and then they need to fix it.
The 71-year-old author wrote a lot about true crime. Court TV legal correspondent Julia Janae examines some of Brophy's chilling writing and explains why she won't have to answer for some of those writings on the stand.
Nancy Brophy's attorneys describe her as a woman with a mildly dark sense of humor. A 71-year-old author who may have wrote about true crime but didn't live it.
We're given 4 dozen oysters to each team.
Students found Brophy's husband, chef instructor Dan Brophy, shot to death at work on June 2nd, 2018.
We were there with police cars, police tape, police all around the perimeter, and we had officers sitting on that perimeter since the morning upon their arrival that were canvassing people as they were leaving all the apartments, driving away, documenting license plates, asking if they saw anything.
Detectives scoured Nancy's life, finances, and writings for 3 months before naming her a murder suspect. It's an investigation that revealed some chilling writings that a judge ruled won't be used against the author in a court of law. This blog post, titled "How to Murder Your Husband," was written by Nancy 7 years before she became a widow. The police aren't stupid, she writes. They are looking at you first, so you have to be organized, ruthless, and very clever. Husbands have disappeared from cruise ships before. Why not yours?
Well, you have to be able to connect the statements that are made by someone or the research that they've done to the actual crime itself. You have to be able to overcome certain other evidentiary rules so that the jury isn't misled by substantially prejudicial information.
The racy title alone isn't enough to make the blog admissible evidence, says constitutional law attorney Andrew Cherkasky.
And so what this case is all about with her past statements comes down to a matter of whether it's closely enough connected to the various aspects of this case, both in time and in detail.
Nancy Brophy's collection of works included romance novels entitled The Wrong Husband, The Wrong Brother, The Wrong Cop. On her website, it says that she once held a book signing at this local bookstore near her home back in 2016. These were self-published works and sold on Amazon. A search of government records showed it doesn't appear that she ever filed for a copyright of any of those works. Novels that she described as being about pretty men, strong women, and families that don't always work.
Nancy Brophy was maintaining all those life insurance policies while continuing down a path of financial ruin. Investigators discovered, as I said, well over $1,000 per month was being paid into these policies at a time that they were struggling to even pay their mortgage.
Prosecutors tried to get the article in by arguing it showed what Brophy was knowledgeable about. But the post, written as part of a writer's workshop, suggests using a variety of murder weapons, including a knife. Dan Brophy was killed with a gun. Nancy also writes, fade from the scene. Get your payment up front from someone else, because life insurance probably won't send a check. In reality, Brophy called police a few days after Dan's death. In this recorded conversation, she speaks of wanting to speed up her life insurance payout.
So my insurance company said, well, just have the detective write a letter that you're no longer a suspect. And I said, man, I just don't know that he's there. And I'm not sure that he looks at it that way. But if you do, I'd get you to write the letter.
You're always concerned about a few things when bringing in past statements, whether they're written or whether they're oral from a defendant. And number one, it's a First Amendment right. People should not be punished just because they said something. And number two, it's because you want to make sure that the trial is fair. And there is certain types of evidence that tends to have such a prejudicial effect on a jury
While Cherkasky doesn't think the First Amendment would be a strong defense argument, he believes there may be one way those words from the how-to article could make it on the record.
If she takes the stand and tries to claim that she didn't know how to do it or wasn't sophisticated, that she didn't have the means or the wherewithal to do it, if something like that comes out, now you could definitely get into the past statements to show that she does have that sort of knowledge and information to be able to commit a crime.
Brophy's defense team told jurors during openings on day one she will take the stand to maintain her innocence.
Still with us, former criminal defense attorney Kirk Nurmi. All right, Kirk, first of all, do you believe in coincidences or not? How telling is it, or is it not at all of matter that she wrote that 7 years before she's now accused of murdering her own husband?
I don't know that that matters. I mean, we talk about writing books and fiction books and things like that, and I've written books before. That doesn't necessarily correlate, and I think the judge was right to keep that out because it is overly prejudicial. Even that article from the Writer's Workshop, How to Kill Your Husband, even the title alone, putting aside any of the substance, is just overly prejudicial, and the jury probably will not get past that in reaching the verdict, so it's rightly excluded.
I agree with you. The overly prejudicial and the fact it was 7 years before, so the relevance for me would be hard to find. I just think it's a good decision. Talk about the impact, if any, of a 1 week unavoidable delay. We know the jury was supposed to be back on Monday. Now it's delayed a week due to COVID. Of course, understandable, unavoidable. Does that have any impact on a jury, in your opinion?
Well, I think it has a couple impacts potentially. You know, one of the things is we know one of the state's last witness, if not their last witness, was this accountant, the forensic accountant from the police department, who really nailed down the motive, right? I mean, we had a bunch of pieces of circumstantial evidence, and while the state doesn't have to prove motive, motive is a great way to tie those together, and I think this witness did just that for the state. The flip side of this is now that Ms. Brophy, who's foretold the idea that she's going to take the stand, herself and her attorneys now have a week to go over every single thing that came up during the trial that she's going to have to address, because she is going to have to address the financial issues. She's going to have to tackle motive when she gets on the stand, as well as reasons why she wouldn't want her husband killed. So now she's going to have a week to ruminate on that and work specifically with her attorneys, and that's going to be to her advantage.
And you're right, Kirk. Not only that, but they now have a week to go through how opposing counsel has been asking questions, treating witnesses to prepare her for how to respond to the personality of opposing counsel, and they have longer to do that now. She has been a defendant that's been a little bit different than a lot of the defendants we see here on Court TV on the major trials that we cover. Often you see a defendant who's very stoic and doesn't have much of an expression, maybe taking notes, may lean over to their attorney to say something, but she has been described by all of our Court TV staff entering that courtroom as someone who stares. She stares at people when she sees them. She stares at the jury. She stares at the witnesses. What kind of demeanor of that nature, what effect does that have on the jury, if it does, in your experience?
Well, you know, I think that can be hugely damaging, because you talk about all this thing, and it's been really described as glaring at certain people. And I notice now we're seeing her in video. She does have a mask on. I remember seeing her earlier in the trial that she was the only one without a mask on, which told me that she was really liking the attention. She was really wanted to glare down all the witnesses. And I think that can be really huge, because we talk about likability and credibility when she takes that stand. And if she's looking at scowling at witnesses, scowling at reporters, etc., that's not going to leave the jury with a favorable impression, and she's going to start at a deficit in terms of connecting to the jury when she takes a stand.
Let me ask you, Kirk, because we know you represented Jodi Arias. How much do you think that the jury noticed of any and all behaviors, movements, actions by your client?
Look, taking it out of the realm of Miss Arias, I always tell my clients, the ones who are out of custody anyway, that, you know, trial begins when you get into the parking lot, because your behavior is going to be assessed. It might be, you know, a juror that you're walking into that you're going for a parking spot against, et cetera, et cetera. Jurors, and that's why we have 12 jurors, can notice everything and bring that into deliberation and offer their theories. So every single movement of a defendant during the trial is always under the microscope, probably by, at least one jury, if not more. So that is so important, and it's hard to say how that, digests with a particular jury, but a defendant is always the person most under the microscope at a criminal trial.
And they don't miss a thing. I will tell you, in my experience on the bench, they see everything. All right, you're going to stay with us, Kirk. And coming up, viewers spoke. We listened about new developments they want to hear on the case of the missing Colorado mom, Suzanne Morphew. Her husband, the person of interest, will remain a free man